Welcome back for the second lecture for this week. First lecture, we talked about defenses, criminal defenses, and just some broad things. We gave you some big definitions to define what we're talking about. We defined criminal defense. We separated them out into perfect and imperfect. We talked about the difference between a negative defense versus an affirmative defense. And then we said that all defenses can classify into two different categories. All affirmative defenses can classify into two categories, justification and excuse. So what we're going to do now is going to specifically start talking about what are some of those excuse defenses. I'm sorry, justification defenses. Can't speak right tonight. Okay, so what we're going to do is talk about justification defenses today, and we're going to focus on the first two, necessity and consent. Okay, so just a review, remember, criminal liability needs all of these things. We're on justification defenses. Okay, so that's what we're going to be finishing up all this week. Now, remember we said all affirmative defenses are either justification or excuse. Those are big categories. There is no such thing as a justification defense. That's not a name of a specific defense. That's a category of defenses. So justification defenses is basically when the defendant says, I did it. I admit I did it. You proved all your elements, all the parts of the wheel, and I did it. But I was right in doing it. I was legally right in doing what I did. So these are going to be the groups of justification defenses. Now, there are three basic justification defenses: self-defense, necessity, and consent. We're going to go through each of these one by one. We're going to start with this lecture just talking about necessity and consent, because self-defense is really detailed and has a lot of parts to it. So we're just going to look at necessity and consent here, and then we'll save the last lecture video for self-defense. Okay, so a necessity defense. Remember we said it's a defense where you said, I did it, but I had a valid legal right to do it. Now, necessity being one of them. Basically, necessity is the idea that you needed to commit a criminal act in order to prevent a worse evil from occurring. So you're justified in what you chose, because if you didn't choose it, something worse would have happened to you, okay? Now, what's important to remember with necessity, it's not another person forcing you to do it. It's the circumstances that you're in that are forcing you to do it. And it will make sense when I give you some examples. So how do you do this analysis for this defense? Well, you have to first think about what are the two bad things that are happening to you, and you rank them. So you're being faced with two bad choices. One is to commit a crime, and another is something else more evil that's going to occur, okay? So you take those two bad things and you rank them. If you have, and you also have to have reasonable belief that that other bad evil is going to happen now. It's imminent. Imminent means now. Okay, so you have two bad things, and one of them is going to happen now if you don't commit a crime. Okay, that's part of the analysis. So you rank the two. As long as the other thing than committing crime is worse than committing a crime, then you're okay to engage in that criminal activity, as long as that worse evil is just about to happen. Now, please, please, please remember that no person can be involved in necessity. So it's not one person forcing you to harm another person. You can never do that. You can never use necessity to harm a person. You can only use necessity as a defense if it's for a crime that's not a crime against a person. So property crimes, morality crimes, public order crimes, but no crimes against persons. Okay, so let's look at some examples, and I think it will make more sense to you. So the first thing, can you destroy a home to stop the spread of a fire? So there's this fire that's sweeping through, and if you destroy this one house, knock it down and create a barrier, then it can stop the fire from spreading further. So what do? You have to think about the two evils. What are your two evils? Number one, stopping a fire, or number two, destroying a house, criminally destroying a house. Which one's worse? The fire spreading, because it could hurt or harm more people. It could burn down more houses. So stopping that one house from catching on fire could stop the rest, then it's going to be okay. So it's probably okay. So if you knock that house down to stop the fire, it's probably going to be a valid necessity defense. What about this? Can you violate a speed limit to get a dying person to the hospital? So think in your head, what are the two bad things that are happening? Somebody could die before you get there, or speeding. So when you rank those two things, which one's worse? The person dying. So can you speed to get there before the person dies? Probably. Okay. What about this one? Can you throw cargo overboard to save a sinking ship and its crew? So you work for a container ship, you have all these corporations, products, they're all on your ship, and you're responsible for them, and that's property. Can you throw them overboard if it's going to save the ship from sinking? So what are the two bad things? Destroying property or sinking ship and killing people. So clearly the sinking ship's worse. So can you throw the cargo overboard? Probably. Okay. What about this? Can you dispense drugs without a prescription in an emergency? So there's an emergency, tornado goes through, there's people that are really hurt, it hit the pharmacy, and somebody's really hurt and you need to give them some sort of medicine right away to help them. Can you do that without a prescription? Well, what are the two bad things? Giving drugs without a prescription, or saving the person's life, or not saving the person's life, the person dying. The person dying would be worse. So can you give them drugs? Probably. Okay. So one of the things I should make clear here, the reason why I'm saying probably is because you have to convince the jury to believe you. So what's going to happen with defenses most of the time is the prosecutor is still going to charge the person, and it's the defendant then that puts forth the evidence so that the jury would not convict. So first, in all the defenses, the judge has to determine if it's a valid defense before the judge will allow the defendant to present it to the jury. So if you get by the judge, then the next step is you have to get the jury to believe it. And that's always hard. So juries don't always like defenses. So you're going to have to convince the jury of your defense. And that's why I say probably, because it's always up to a jury. Can you break and enter a mountain cabin to avoid freezing to death? So you're in the Adirondacks, a storm blows in that you didn't expect. You can't get back to your car. You're going to freeze to death. So you see a cabin and you break the window and you go in to save yourself. So what are the two bad things? Freezing to death, breaking in a cabin. Which one's worse? Freezing to death. So can you break in the cabin? Probably. Okay. Oops. Can you eat a dead body to avoid starvation? So if you ever saw the movie Alive, there was a plane crash and they were out in the mountains. Nobody came and found them for a long, long, long time. Could you start to eat the body? So obviously that's cannibalism. It's a dead person. It's cannibalism, which is a crime. So the two bad things, eating a dead body, starvation. So usually eating a dead body would be a crime. But if it's to avoid starvation, can you do it? Probably. Okay. Can you kill someone to eat their body because you want to survive? So now it's you or them, and whoever dies first, you get to eat the body. So can you kill them first to save yourself? And not this, you cannot do. Because remember, I said you can never, ever, ever use necessity to harm another person. So if you're thinking about in your case study, using necessity for any sort of physical harm to a person, you cannot do it. It would not be a valid defense. But try not to ever write necessity for any harm to persons. Okay, let's talk about the next one. The next justification defense is what we call consent. Consent is when the victim voluntarily engages in the conduct so that the defendant can't be responsible for harm that that victim suffered. So the victim is basically agreeing to the criminal conduct, agreeing to be a victim to the criminal conduct. Okay. So what do you think of these examples? What if you get hit by a baseball pitch? Did you consent to that? Right? So I'm standing at the home plate, I'm waiting, and somebody pitches and hits me in the arm with a baseball. Is that an assault? Or did I consent to be possibly hit by a pitch when I'm decided to play baseball? Is it part of the actual game that I consented to? What about this? Can you punch someone in a football game? So you're getting a football game, you go tackle each other, you get kind of annoyed, and you throw a punch. Did the person consent to being punched when they agreed to play football? Is it part of the regular football game? Have you ever watched a football game and saw somebody get punched? Were they criminally arrested and taken off the field and charged? Or is it kind of something normal that may happen in the game? Can you shoot BB guns at each other? So kids are stupid and they get BB guns and they're like go in the woods and they shoot each other with BB guns. Can you consent to being shot with a BB gun? Can you consent to a fist fight, right? So I'm mad at you. You did something to me. We're going to meet by the clock tower and I'm going to beat the crap out of you. And you're like, okay. And you meet me and we engage in a consensual fist fight. Is that consent? Can neither one of us then be charged for the fight? So what's important to remember is there's only certain times when you are permitted to use consent as a defense. So these are the rules for using consent. Number one, you cannot use consent if anybody could be seriously injured. So you cannot ever consent to serious injury. So the fist fights, the BB gun, I could get an eye shot out, which would be a serious injury. You cannot consent to that. The law will not allow the victim to consent to the possibility of being seriously injured. So the defendant cannot use consent. So remember, I said first you have to get by the judge and then you have to convince the jury. The judge is not even going to allow you to present this to the jury if serious injury could occur. If it's an injury that could occur from a regular sporting event or part of that actual sport, you can use consent, okay? So it's for things that could normally happen during that game, getting hit by a pitch, getting punched with the football when you're playing football. Those things are part of a sporting event. But let's say I'm up at bat, I get hit by a pitch, and then I go and I take the bat and I beat the pitcher over the head because the pitcher hit me. Is that a normal part of the sporting event, or does that go beyond what somebody would consent to at the sport of baseball? I would argue it goes beyond, and so no, you cannot use consent for that. You can consent even if the harm is going to be beneficial. So I can consent to surgery. Now, surgery is causing me serious physical injury. If you're going to cut my body open to do something, then that is a risk of serious physical injury. But if that serious injury actually leads to a bigger benefit later, like patient surgery, then that's going to be okay. We're going to allow that. So you can use consent for that. What we're going to see mostly is consent to sexual acts. So when we get into the sex offenses, that's where you're going to see consent as a defense used the most. Okay. Now, a couple rules with consent. In order for it to be permitted, the consent has to be voluntary and knowing. Voluntary means the victim of their own free will consented to the action, right? So it was voluntary. They weren't coerced. They weren't forced. Nobody made them do it. They voluntarily agreed to participate and they were allowed to. Knowing means they understood the consequences. They actually understood what they were saying. So if they're drunk, if they're on drugs, if they're too young, if they have mental illness, if they have mental disabilities, then you can, or like intellectual disabilities, you cannot use consent because the victim's consent would not be knowing. So it has to be voluntary and the person giving it has to know and understand what it means to give consent. If the victim doesn't meet both of these, so first they have to be in a circumstance where you're allowed to consent, which we just went over these. So it has to be a place where they're even allowed to consent. And then if they do consent, we have to assure that the consent is voluntary and knowing. Okay. So think about this. Can a defendant accused of hazing plead consent of the victim? So you have somebody wanting to join a band or a fraternity or a sorority or a club or a sport, and they are being hazed and they have to go through certain hazing activities. Can the defendant say, and let's say the victim was hurt, can the defendant say, well, no, 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 they consented. They pledged my fraternity. I was allowed to do it. It's consent. And the courts have said consistently, well, think about it based on the rules. Is there a likelihood of severe injury? And the answer would be yes. So no, we would not allow consent in those situations. Okay. So like I said before, most of the time where you're going to see consent is going to be with the sex offenses. And we're going to talk way, way more about consent when we get to the sex offenses. So what about this? Let's just kind of think a situation through. Fran tells the victim that she would shoot the victim if she had a gun. The victim gets up, goes to his car, loads a gun, returns to the bar and hands it to Fran. Fran then shoots the victim. Can Fran be charged, or is there consent? So the victim went and got the gun. The victim handed the gun to Fran. Isn't that a valid consent? So think back of the rules we just said of when a person can consent and if it's allowed, okay? And in this case, there's a risk of serious physical injury, so consent would not be allowed, okay? So no consent. There's a chance of serious physical injury. So I hope this is making sense to you. Okay, so I'm going to give you two scenarios. You decide which justification defense it is. Is it consent or is it necessity? So read each one, stop the video, read through them, try to figure it out. Which one is consent? Which one is necessity? And then when you're all set, start the video again and check your answers. So the first one would be consent and the second one would be necessity. So hopefully you understand. If you have any questions, just shoot me an email and I'll be happy to clarify. Okay. So now you can complete your, you decide one in Mind Tap for chapter 5. I think it deals more specifically with this, so you can dive in. So that's all for the second lecture. So the next one's going to be a little longer because it's self-defense and there's a lot of pieces and a lot of requirements for self-defense. It's going to take us a little longer to go through all of that. But hopefully you understand the two other justification defenses, necessity and consent, and just reach out if you have any questions about any of it. Okay, have a good night and I will see you soon.